the crazy AG and judge in New York, going after Trump, your friend. So you need to, we need to exercise those two persons, the AG and the judge. They're crazy, okay? So we need to watch this video.
This week, Donald Trump started his civil trial in New York. When I looked into the details of this case, I was shocked at what I found. No one in the news is telling you the full story. So we're going to cover it here this week on Wolves in Finance. For those of you who are new to my channel, my approach is to cover stories in a fair and balanced way. I'm not pro-Trump, I'm not anti-Trump. In fact, I've not endorsed any candidate for president, and I'm waiting to hear what they have to say during the debates before I make up my mind. I'm also a certified public accountant, so I'm going to be able to explain the fraud allegations from an accounting perspective so that you can understand what's really going on here. Let us look at the facts of the case. This is one of the many court cases being brought against Donald Trump. This one is being filed in New York State Court. New York is suing Donald Trump for 7 civil claims, including fraud, falsifying business records, conspiracy to falsify business records, issuing false financial statements, conspiracy to falsify financial statements, insurance fraud, and conspiracy to commit insurance fraud. The trial centers around financial statements the Trump Organization used in 2011 to 2016 to receive bank loans. The Attorney General alleges that estimates in those statements were inflated, which resulted in the 7 civil claims of fraud. Let me set the stage by explaining the people involved in this case. The case is being brought by New York Attorney General Letitia James. This woman campaigned for her job on the promise that she would get Trump. Here's a clip from one of her campaign ads where she explains that she is going to work with attorney generals from across the country to remove Trump from office.
I believe that this president is incompetent. I believe that this president is ill-equipped to serve in the highest office of this land. And I believe that he is an embarrassment to all that we stand for. He should be charged with obstructing justice. I believe that the President of these United States can be indicted for criminal offenses. And we would join with law enforcement and other attorneys general across this nation in removing this president from office.
I am surprised these statements do not disqualify her from bringing this case. This is evidence of malicious prosecution, which would be using the Justice Department as a weapon to attack her enemies. That is wrong, and it's illegal. But let us also look at the judge in this case, Judge Arthur Engoron. This is a Democrat judge with a history of donating to the Democrat Party. To give you an idea of who this judge is, there's a clip floating around social media of a speech he gave where he explains that he does not like juries.
I'm going to say something controversial, even though I'm being taped. Juries get it wrong a lot. That's my own opinion. I do only civil trials, personal injury cases, contract disputes. But I've had situations where, like, oh my heaven's sake, how could they have thought that? Well, I have a tool that I can deal with that. It's called jury notwithstanding the verdict, judgment notwithstanding the verdict. I can say there is no possible way that a reasonable jury would have reached that conclusion. And all right, am I following the law or am I making law? Okay, I'm following law. I'm an impartial referee, but it's hard to factor out my own emotions.
So he says that juries get it wrong. And if he doesn't like their verdict, he's just going to throw it out and do whatever he wants. What? Someone who says things like this should not be allowed anywhere near a courtroom. Judges are supposed to be impartial. If you're walking into a court, you want a judge who will treat the case fairly, or at least give you your constitutional right to a jury trial. So we have a politically motivated attorney general and a judge who has admitted to making biased decisions. What could possibly go wrong here? Let us look at the case. This case is about estimates. In the accounting world, there are a number of ways to perform estimates. When you're valuing property, you can use multiple different approaches. It talks about these approaches in the Statement of Financial Accounting Standards number 157 for fair value measurements. It explains that you would perform your estimates and then you would consider the reasonableness of the range indicated by those results. Who considers whether an estimate is reasonable? The business owner. The business owner, in this case, Trump, decides what is reasonable for the financial statements. The government does not decide the estimate. Trump does. So by definition, an estimate takes judgment and discretion. That normally makes lawsuits about estimates difficult to prove. Because if an estimate is discretionary, who's to say that one person's estimate is better than another? It's an estimate. It's also important to understand that this is a civil trial, so there are no criminal charges being brought against Trump. Wait a minute. That's a bit strange, isn't it? Trump is not accused of committing the crime of fraud. Trump has not been convicted of committing the crime of fraud. He's not been accused or convicted. And yet, the Attorney General is suing Trump for damages from the fraud that he was not convicted of committing. How is it possible that Trump can be civilly liable for a crime when he never committed a crime? That is only the first strange thing about this case. Donald Trump is being sued under New York Executive Law Section 6312. This is a unique statute in New York that allows the state to go after fraudsters and collect damages that may not have been recovered during the criminal trial. How this would normally be used is the state would first convict someone of committing the crime of fraud in a criminal court. Then the state would sue the person in a civil case. In Donald Trump's situation, it's a bit of a stretch to apply the civil law to someone who has not even been charged with the crime of fraud. This is very bizarre. So just starting out, this is a very strange case. In a shocking turn of events, the judge in the case declared a summary judgment on the first fraud count in the case. The judge has already announced the district attorney has won on the claim that Donald Trump committed fraud before the trial even started. The trial occurring this week is to determine the outcome of the remaining 6 claims of fraud. The rest of the trial is expected to take 3 months, but the main issues have already been decided. The result of the judge's order is that Trump's businesses in New York immediately lost their business license to operate in the state. Also, Trump is required within 10 days to hand his businesses over to an independent third party to shut the businesses down. The third party will guarantee that the Attorney General will be able to seize Trump's assets when they are sold. Additionally, the Attorney General is requesting that Trump pay her $250 million in damages. The rest of the trial will determine how much Trump will have to pay. Let us go through this just so that you understand. Trump Tower, seized and shut down. Trump Park Avenue, seized and shut down. 40 Wall Street, seized and shut down. 1290 Avenue of the Americas, seized and shut down. 3 of Trump's golf courses, seized and shut down. Even properties Trump owns that have nothing to do with the bank loans or this case, seized. The government has accused Trump of fraud without a trial and seized his businesses. This is very unusual. Now, what just happened on Friday was that Trump was granted an appeal by another judge to issue a stay in the case. Trump had gone to the appeals court and told them to halt the trial because what was happening to him was so unfair. The appeals judge did not stop the trial, but he did issue the stay to stop the cancellation of business certificates. So now, Trump does not have to shut down his businesses until after the appeal court decides on his case. So just to clarify, Judge Engoron already ruled against Trump in the case. The appeals court said, hold on, they're going to look at the trial when this judge is done, and they're going to decide if Judge Engoron's decision stands. Let me explain the process of summary judgment, because that is what the appeals court is going to look at. The district attorney requested that Judge Engoron issue a summary judgment, which is when the judge unilaterally decides the outcome of a case without going through a trial. What summary judgment is supposed to be used for is for situations when the facts are not in dispute. For example, let us say there's a hit and run accident and the driver is caught on video behind the wheel. That would be a situation that you would typically see a summary judgment used. The facts are not in dispute. We know you did the crime. You're on video committing the crime. There's not anything to argue about. So summary judgment avoids wasting everyone's time. We don't need to pay for a whole trial when we all know what happened. But summary judgment is not used unless the evidence is extremely strong, because you're taking away someone's constitutional right to due process in a trial. So if there's any evidence that you could reasonably dispute, it's inappropriate to declare a summary judgment. It's your right under the Constitution to have a trial and be able to argue your side of the case. In this type of fraud case about estimates, it is unheard of to declare a summary judgment. A lot of the claims made by the Attorney General can be disputed. Donald Trump says his estimates are good. The Attorney General says that their estimates are good. Normally, the whole point of a civil trial is to allow the parties to argue their side in court. So it's bizarre for a judge to determine that the district attorney's method of estimating is so strong that there is nothing to dispute. Estimates, by their very definition, are a matter of judgment, not fact. So by definition, it would be inappropriate to declare summary judgment based on estimates. Donald Trump has a constitutional right to be able to argue his side in court. But no! The judge looked at the evidence and declared that Trump was guilty of fraud, even though he has never been charged or convicted of the crime of fraud. So let us look at some of the evidence that the judge claims is so strong that it warrants a summary judgment. Trump owns a real estate business, so his financial statements are a list of his different properties and their valuations. One example everyone is familiar with is Mar-a-Lago, Trump's beach resort in Palm Beach, Florida. The judge reviewed a document created by a local tax assessor in Palm Beach County who calculated property taxes based on a valuation of $18 million to $27.6 million. Donald Trump's valuation was between $427 million to $612 million. The judge decided that the $18 million valuation is the correct price of Mar-a-Lago and writes that Trump fraudulently claimed an overvaluation of at least 2,300%. Just to emphasize what this judge did, he took the low end of his estimate, compared it against the low end of Trump's estimate, and that calculates out to a difference of 2,300%. This shows how ridiculous the evidence is in this case. It's common knowledge that if you're going to sell your home, you don't use the bill from your local property taxes to set the sale price for your property. That's absurd. Tax appraisers have all kinds of unique rules and formulas to come up with your property tax bill. There's no relation between a property tax bill and how much Mar-a-Lago should be valued on Trump's financial statement. In fact, the chief property appraiser for Palm Beach County has given a public statement saying that the Mar-a-Lago assessment was based on assessments for tax purposes only and not for financing or for a lending institution. He also explained that the $18 million valuation was based on annual membership dues and the expenses that it costs to run the facility. It has nothing to do with the value of the property. Have you seen Mar-a-Lago? It's amazing. Anyone with half a brain knows that Mar-a-Lago is worth way more than $18 million. This is 20 acres of beachfront property in Palm Beach, Florida. Is this judge insane? You can do a Google search for properties for sale in Palm Beach that are worth way more than that. Here's a tweet by a former investment banker, John LaFarve, and he went on the Zillow website and found a vacant lot nearby Mar-a-Lago for $200 million. So even with nothing on it, it's worth $200 million. And it was only 2.32 acres, much smaller than the 20 acres of Mar-a-Lago. You can also ask ChatGPT. In fact, I asked ChatGPT in preparing for this video, and in 2 seconds, it told me the valuation of Mar-a-Lago was between hundreds of millions of dollars to over $1 billion. Even ChatGPT knows this judge is wrong. All the evidence that everyone can see shows that the judge is wrong. To emphasize her side of the argument, on Thursday, Attorney General Letitia James posted on Twitter this image where she is comparing her estimate against Trump's. Here, she uses $25 million. Once again, this is unclear. Is she estimating 18 million or 25 million or 27 million? Which is it? Whichever one it is, it's still stupid. According to a recent article in Forbes, Mar-a-Lago brings in $29 million in revenue each year. Think about that. In 1 year, Mar-a-Lago will bring in more money than Letitia James is saying it is worth. No sane person would value it at only $25 million. What's really crazy is that everyone's been making fun of Letitia James's estimate since it was released. And still, she posts this on Twitter like she's proud of it. Really? Don't you see that everyone on the internet is calling you an idiot? It's like she doesn't even care. She's not even pretending anymore that the law has to make sense. The whole point of this example is that property valuations are just an estimate. The Attorney General has her estimate. Trump has his estimate. The judge has his estimate. None of these estimates are enough evidence for the judge to declare summary judgment, deny Trump due process, and then seize all of his businesses. Here's the real question. Isn't the judge doing the same exact thing he's accusing Trump of doing? The judge came up with an estimate for $18 million. We can all see that it's a ludicrous estimate, and he's trying to pass it off as legitimate. Under the judge's own definition, he just committed fraud. Someone needs to arrest the judge. And this judge should get the same treatment. He should get no trial, no jury, just a guilty verdict for this ridiculous $18 million estimate of the value of Mar-a-Lago. How do you think the judge would like that? I'm betting he wouldn't. Do you know why? Because it's not fair. But it gets worse. The alleged fraudulent financial statements were what is known as compilation statements. This is a very specific term in the business world. In the accounting world, auditors can perform three types of financial statement audits. They can perform an audit, a review, or a compilation. An audit is the most thorough inspection of financial statements. A review is less thorough. And a compilation is basically just throwing together financial documents without reviewing them. It's not meant to be the most accurate method of reporting. An accountant who creates a compilation is not providing an opinion on whether the numbers in the report are accurate. Trump used compilation statements to give to the bank for a loan. The bank knew it was a compilation, and they were fine with that because the bank reviews the financials with their own appraisers anyway. The bank is saying to Trump, give us your quick and dirty financials and we'll do our own checking. So the bank has no complaints. In fact, Trump has already paid off the loans in full. So just to review, no customers have complained. There were no victims. No one lost any money. This is about estimates, which involved a matter of judgment anyway. This was a compilation which was not supposed to be the most accurate financial report in the first place, and the bank was aware of this and was fine with it. How is this fraud? And how in the world is this judge allowed to issue a summary judgment about this case without a trial? Let me also add here that this is completely normal in the business world. It doesn't appear to me that anything fraudulent is going on here. Businesses create compilations all the time. It's the quickest and cheapest way to put out a financial statement. So from the bank's perspective, this was normal. It's very difficult to believe that the banks were defrauded in some way when Trump was upfront and honest with everything, and the bank knew exactly what was going on. On top of all of that, the financial statements included a legal disclaimer, which explicitly told the bank that they cannot rely on the estimates. They were explicitly warned that the statements included estimates that may be inaccurate. The whole point was that the bank was expected to do their own assessment, which they did. This legal disclaimer normally makes it impossible to sue someone for fraud. But despite all of this, the judge has decided that the legal disclaimer does not mean anything. What? If legal disclaimers have no meaning, why do we even use them? Of course they have meaning, and it is completely absurd for a judge to ignore legal disclaimers that are common practice in the industry. But the most sinister thing in the judge's summary judgment is his implementation of New York Executive Law, Section 6312. The judge's ruling expands this law dramatically. He cites another court ruling in People v. Northern Leasing, which he claims expands fraud to encompass new liability while including non-statutory fraud claims. He is saying here that New York's definition of fraud is broader than the criminal statute, so he is justified in convicting people of fraud even if they did not commit fraud. He then cites another court ruling in People v. Interstate Tractor Trailer Training, saying that Executive Law 6312 does not require demonstrating an intent to defraud. So not only do you not need to commit fraud, you don't even have to have intent to commit fraud. You could simply make an innocent clerical mistake, and the government could convict you of fraud under this statute. If you check the wrong box by accident, fraud. If you mistype a number by mistake, fraud. With this judge's new expanded interpretation of the law, the government can now go after anyone for anything. Now, of course, Trump's lawyers argued against all these points in their brief against the summary judgment. They claimed what the judge was doing was not fair. In another shocking ruling, the judge sanctioned all of Trump's lawyers, forcing them all to pay a $7,500 fine each. He argues that they had brought up these points previously and had been overruled. By including their arguments again by speaking out against a summary judgment, he accused the lawyers of making frivolous arguments that are completely without merit in the law. Here's the problem. I read the judge's summary judgment order. In my opinion, it's wacko. That's my opinion. Judges are supposed to be impartial. This order is so biased and so favorable to the Attorney General, I found it shocking. The mental gymnastics that he had to go through to make his decision are absurd, and the result is also absurd. What's happening here should horrify anyone. What this judge is essentially saying is that the government could charge any business owner at any time for fraud. It doesn't matter if you actually committed the fraud. It doesn't matter if their allegations make any sense. You will not even get the right to a trial to defend yourself. Not